And thanks for joining us here on PM Express. There's this debate that has been raging since last 2 weeks that we want to get into because it really has to do with the judiciary. But also, there have been a press conference by the NDC last week. We've seen today the majority leader also weighing to this. Yesterday, we saw the former President John Dramani Mahama weighing to it also. The Chief Justice also weighing into it. We're now having a conversation about this tonight on PM Express. Why more judges to the Supreme Court? There are two sides to this particular debate, the justification and the opposition. Let's look at what really triggered this conversation. Because the Chief Justice initiated a process, and it has been described as strange, it has been described as not normal. We'll get into that. Some even use the words unconstitutional. I have the lawyers with me to break that down for you. But the Chief Justice went ahead, initiated a process, and recommended the appointment of Justice Ifeasewa Sare Boche to the Supreme Court. She was not alone, and by the way, she qualifies. For many, it's long overdue because of her own competence and strength on the subject, one of the no-nonsense judges that you can find, and she is really a blessing as far as the judiciary is concerned. She was put up for consideration, together with Justice Pamela Cranting, also put up for consideration. There were 5 of them in all, including Justice Edward Asante. And also we saw Justice Eric Bafo, also recommended by the CJ, and Justice Angelina Mensah, also recommended. 5 of them, right? At the time when they were recommended, we didn't quite get wind of it until it circulated that she had indeed done so. Now, that sparked a controversy. The first controversy that erupted around this was, did the CJ really have the authority to initiate that particular process? And quickly, the lawyers and those who were criticizing her pointed to the Constitution. Article 144.2, they cited. They said, well, that process is to initiate the process is the President's preserved to do. We'll get into that because the Constitution is clear on this matter. The President shall appoint the other justices of the Supreme Court, one, on the advice of the Judicial Council with the CJ chairs, in consultation with the Council of State, and with the approval of Parliament. So 3 different functions, 3 different institutions. When it comes to the Judicial Council, they have to advise. When it comes to the Council of State, the President will consult them. And then finally, Parliament will approve. Okay. In that whole chain, the Chief Justice only sits and is activated as a chair of the Judicial Council, not starting the process and recommending herself, which is really what their critics have pointed to. That is the first line of controversy that emerged on this particular subject. And then the issue then also moved now. It has actually now become, do we need more judges, more justices at the Supreme Court? Currently, we have 15 of them, and the CJ is arguing that they aren't enough. Let's get into the specifics of the justices. So the recommendation that she's made is to increase the number from 15 to 20 justices to the Supreme Court. And as far as she's concerned, you see her in your picture there, it is a case of what the science says, because there's so many cases currently pending. The backlog is growing. If you really want the administrative justice to be effective and avoid delays, and the lawyers will tell you that justice delayed is justice denied, then you really need to increase the numbers at the Supreme Court so they can do their jobs and do it effectively. So that is fundamentally her case. Then she begins now, as we've now seen the documentation, in February, she writes to the presidency detailing strong argument backed by numbers to make the point why you need more judges. We've now seen that document, right? And then in April, we've seen the Attorney General also write his own opinion on the side, because the presidency says, we've received this matter, this document from the Chief Justice. We want your opinion on the matter also. So in April, the Attorney General writes his and was received on the 2nd of May at the Jubilee House. But the numbers here are interesting. And so this is what you see there in terms of the backlog of cases, and it's been climbing. If you look at the 5-year period that the Chief Justice's own document focused on, this study, this assessment that she did, which really anchored her decision to recommend the nomination and appointment of these 5 other justices, she sort of traces the backlog. In 2018, when he started tracing it, she started tracing it. It was at 202 cases, backlog, not head, cases in the pipeline that because she argues we don't have enough judges, they haven't managed to answer or deal with it. And then you come to 2022, where it's now climbed all the way from 202 cases to 595 cases. That is a CJ's point, put it simply, that this is obviously justice that has slowed down for a lot of people who are struggling as a result of the numbers that are in short supply, so increase it. Okay. The NDC obviously is opposed to this particular subject. John Dramani Mahama says we need to place a cap and consider that, because I'll come to the point about what the Constitutional Review Commission also looked at. They traveled the country and they came to the conclusion, having consulted majority of us, that what Ghanaians want at this time, having implemented the Constitution for so long, is to place a ceiling on this, place a cap on it. The AG is then asked to look into what Attorney General has asked for, and he goes into it and then agrees with the position of the CJ, because fundamentally his argument is that if you increase the number of Supreme Court judges, what you do is you make the administration of justice effective. And by the way, it is constitutional. Why? Because as we have currently, there is no cap, there is no ceiling in the Constitution. It just says you must have a minimum of 10. If you add the Supreme Court, justices of 9 and the Chief Justice herself to it, you come to that conclusion. So there's no legal issue there as far as he's concerned. But he's not interrogating the subject of procedure, right? He is interrogating the issue, do we need more Supreme Court judges? And that's why he comes to the conclusion that there's no illegality there. He talks about jurisdiction, so the Supreme Court needs to be amended, because if you look at it, I was counting some, in terms of the responsibilities that are assigned to the Supreme Court itself, 8 in all. And it does a comparison with, say, the UK Supreme Court, which has that appellate jurisdiction solely. And then, of course, other issues come into play. But mainly that's all they have. And they have 12. And he's comparing that to that. Then you go to the Supreme Court. And he makes the point that if you go to the Supreme Court, every state have your own Supreme Court. 344 of them assisting the federal Supreme Court, where you have 9. And he sort of isolates that point to say you cannot compare the two. We'll get to the specifics when my lawyer friends join me for a conversation. Also hear from the NDC, because John Dramani Mahama yesterday makes the point that for him, we need to return to what the Constitutional Review Commission has said, and that let's put that before the Ghanaian people. What do we really want? Yes, 1992, when we were drafting this particular constitution, we said we only need that minimum number of 10. Having practiced it and implemented it for so long with the current controversies, and we've seen that sometimes it's become a subject of political football. You can actually send people there, and the Kufuor's administration is well documented. If you have a case you want to win, it is subject to manipulation, right? So why don't you place a ceiling there? In fact, if you look at the Attorney General's own document, he makes the point about if you increase to 20, it has financial implications for the public purse also, because they retire on the salaries and you have to pay them, that particular amount as they retire. So it's a very complex, detailed conversation we must have. And the time is right, because the parties are campaigning to form the next government. If we make this a subject for campaigning, at least it becomes a serious issue for the two main parties who most likely will form the next government. But we must shape the conversation. What should be the focus? Should we place a cap on it at 20 or 15, or we just leave it for a president to come and say, I want to appoint 50 judges? That is open for interpretation. We'll get to that when my guests join me for a conversation and sit down for this. If we look at the 1992 Constitution, though, and I wanted to make this point, because this is something that we've spent money in doing. We cannot throw this away, which is the point of John Dramani Mahama there. He would take this Constitutional Review's report to the people of Ghana for consideration. And they were very, very clear on the subject. What do we do? Amend the Constitution. They say, provide that ceiling of 15 justices of the Supreme Court. They say new provision should be made difficult to amend, entrench it, in essence. So you place a cap and you stick to it. But would you reduce the duties assigned to the Supreme Court then from what it is currently, 8 of them in all, if you're counting from the Supreme Court's duties and responsibilities, assigning the Constitution to something lesser, maybe like the UK one, and assign the rest to the other lower courts? I don't know. It's a conversation we must have. And then you look at the various presidents we've had. All of them have appointed judges to the Supreme Court. The president with the highest by far, as you see on your screen there, is Kufuor, and of course, you also have Akufo-Addo, who has appointed quite a lot. But if you look at the arguments, it's because he anticipates that some of the judges will be retiring, and so you put people there. But he's had the opportunity to do quite a bit. And you see JM there, only 4, Atamil's only 3, Rawlings 10 in his time there. So this, you cannot ignore the question about the politics, because it's in there somewhere, and we need to try and find it. Where do we place the facts? Where do you see the politics? Or where do you see the national interest? My guest will join me for a conversation on this after this. And thanks for staying with us here on PM Express. My guest joining me for a conversation tonight is Xavier Kudji. He's the spokesperson for the Ghana Bar Association. They have an opinion on this, and I really want to get into that when we get into the specifics. Also joining me is private legal practitioner Kweku Pentil is with me in the studio. We'll be joined by the NDC National Communications Officer, who is a lawyer himself. And of course, he was there yesterday emceeing the program when the former president stated his position on this particular subject. I want to get into that. The NDC has a position, by the way, articulated by the General Secretary at the news conference last week on this particular subject, and I will get his thoughts also on this. Remember, the PM Express is always brought to you by Syntax Tanks. It is strong, it is tough, and also by Euros 2024 and our coverage here at the Multimedia Group. And no matter your water needs, Syntax Tanks has it all for you. It is a tank that first introduced you double-layer tank, and now you can have as many layers as you want. It comes bespoke. It has 7 years warranty, and they are across the country. Call them on 0244 335 168, 0244 335 168. And you want to really follow our coverage of the Euros. And tomorrow, the semi-finals will begin. And on Wednesday, we will have live coverage for you on radio. It's also going to be across our many channels you also want to follow very closely. It's going to be on Joy FM, on Love FM, Hits FM, Adom FM, Inshrine FM, and Asempa FM. That's where you want to be. If you're driving, especially the game starting at drive time, you want to tune in and listen to the commentary there. My guests are in the studio with me. I'll be joined on Zoom by Sami Jimfi. And I want to start with you, Xavier. And let's break this conversation down in 2 parts. Let's start with the procedure. And then we'll come to the specifics about do we need more judges, because there's a lot there to unpack. But let's start with the procedure. Is it regular to have the Chief Justice initiate this process of recommending to the President names to the Supreme Court?
Evan, thank you very much. If you say initiate the process, maybe I think what is not regular is the Chief Justice directly suggesting names to the presidency. But when it comes to appointments at that level, there are 2 bodies that made the nominations. We have the BAR, the Ghana Bar Association, the Office of the Attorney General, and also the Chief Justice, that is the judiciary. So initiating the process, yes, she can suggest names, those names.
By herself?
By herself and
can
her
suggest
team.
Name.
And her team.
Can just suggest names to the President? Really?
No, not at all.
Exactly.
I'm building a point.
Okay.
And all these names by these bodies will have to go to the Judicial Council. Okay. The Judicial Council then makes a recommendation advising the President on the list submitted. Mm-hmm. But once it's just an advice, not binding on the President. But the President too does not have that right to suggest his own names. So he can only say, I am dealing with, or I accept all the names you have brought, or I'll drop some and use some, or I reject all of them. But he will have to come back to for the process to begin all over. So the Chief Justice regularly does not have to write suggesting names directly to the President. But she has that right as part of the judiciary to suggest a name to the Judicial Council.
The Judicial Council. And I read the Constitution, it says the other justices of the Supreme Court shall be appointed by the President on advice So the president initiates the process?
No, before the president does that, she gets a recommendation from the Judicial Council. That is why it is on advice of the Judicial Council and in consultation of the Council of State.
But he can have his own original list and come to the Judicial Council?
No, he cannot do that. The only time he does that is in the appointment of a Chief Justice. That one, he does it alone, in consultation with the Council of State, with approval of Parliament.
So you're saying that the Judicial Council initiates a process?
Yes.
And then, of course, then the advice say, okay, these are the 5 people we advise you to appoint.
Yes. But it's not binding on him.
Of course, it's an advice.
But he can also prepare his own list. He cannot name anybody. The names must come from the Judicial.
But if it's an advice, he can turn it down.
So turning it down, the authorities...
It would have still consulted you. It would have still taken your advice.
You may have to say that for these 5, I don't think that they are competent to do this job. Bring me another 5. But he cannot suggest names.
Okay. So your verdict on the Chief Justice writing directly to the President is that it's, what, irregular or unconstitutional?
Well, for me, it's irregular.
But it is unconstitutional, is it not?
Because I don't think that she's saying that those people should be appointed. If she had gone ahead to appoint them, I would have said so. For me, I would describe it as irregular. Because, I say irregular because I am not sure with that list that is exhaustive, because Ghana Bar Association has not named anybody in that list. I am not sure Attorney General has named anybody, but I can speak for the bar. The reason I say this is that we have 2 representatives on the Judicial Council, our president, our immediate past president. Anytime they go for meetings, they come and brief us. They have not briefed us that it is that time for us to name candidates for appointment to the Supreme Court. I've not had that benefit. And speaking to my president, he said he didn't come up. That is why probably I've heard that he was leading the charge when this issue came up at the Judicial Council.
He was leading the charge?
Yeah, with the disagreements.
Okay. So he disagreed at the Judicial Council?
Yes. He didn't hear that from me.
Okay. So when was the first time the bar heard about this, as in your reps on the Judicial Council?
No, I think when at their last meeting, I should think so, but I saw it on a certain platform.
Okay.
Yeah. But formally, as I said, our reps have not briefed us that names are being prepared for.
Well, when was the last council meeting?
I think it's sometime last week. It should be sometime.
Because if you look at the correspondence that has now been released from Jubilee, which includes the Chief Justice's position on the matter, she initiates the process in February. At least that's when she put in the argument for increasing the number. I don't know whether that's when she actually suggested the names, no, but that's when...
I don't think so, because when she made a request to the president, a copy of that brief was given to us, just as it was given to the Attorney General.
Okay.
And this was supported with the statistics. Based on that, as a bar, we agreed in principle that, yes, there might be the need for us to increase the numbers to 20, but because the Constitution only gives us a minimum, it doesn't give us a maximum. And we've been operating as a nation with a conventional number, and now we have 15. Then further consultation with bodies like Parliament and Council of State will have to be done. Okay,
so that's you're coming to whether we need more or less.
Yeah, that was what we said.
We'll come to that, because that for me is a key argument here. But I just wanted to reference that document.
So I'm not sure this document that we're talking about containing the list was made in February, because in February...
But this is the document...
Yeah,
this is exactly. This is a document that the Chief Justice sort of penned to the President in February. Yeah. And it bears the received seal of the Office of the President dated 2nd May, right? And the President then, having received it, then writes to the Attorney General to say, we received this document from the CJ. Give me your advice.
That was the request.
And it says here that by the Chief says, I just want to read it. Respectfully, by correspondence, mentioned the date, dated 18th March 2024, headed, and this is the Attorney General writing back on his letterhead to the presidency with his advice. The Secretary to the President seeks the input and perspective of the Attorney General and the Minister for Justice on a brief submitted by the Chief Justice of Ghana, Justice Gertrude Araba Isaba Tokonu, to His Excellency the President of the Republic of Ghana, dated 21st February 2024. That's when then he sort of she lays out, because again, this document also reproduces what she said, lays out the argument and the cases, etc. Does it tally with what you know?
Exactly so. I believe this was signed by the Secretary to the President.
Yes.
Yeah, we had a thing. It was exactly, well, I don't know, but we had a similar letter.
Okay.
And attached to that letter is the breakdown of the workload, just as you projected on your show.
Screen. Yeah. Let me so. On that same subject then, the bar obviously is opposed to the procedure that Chief Justice adopted. Irregular is what they've used. Heard about it for the first time at the Judicial Council meeting. The President opposed it. The President of the bar, of course you're a member of the bar, opposed it. They were right in doing so, were they not, considering the constitutional provision on the matter?
Yeah, the position the Chief Justice has assumed on this matter is unusual. Indeed, and in fact, I'm not too sure whether there has been a precedent. There's a precedent to it. In other words, we have a Judicial Council where this decision mostly rests. And since the Chief Justice is a member of the Judicial Council, I would expect that that would be where all these discussions would normally have taken place, and whatever decision that the Judicial Council comes to would then come out of Judicial Council. That's more reflective of the position and the role of the Judicial Council. So personally, I still cannot understand how it came to be that the Chief Justice on her own initiated this. I wouldn't know what discussions she had, but it has nothing to do with the fact that we don't need more judges in the Supreme Court. But the procedure she adopted is very unusual. And with due respect, and in my honest view, I'm not too sure it's right. That's my view of the matter. I'm not too sure she's right at all in assuming that role and that position and projecting the issue. When we need justices in the Supreme Court, with due respect, it's not the problem of the Chief Justice alone. It's the problem of the judiciary as a whole. And even though we are members of the bar, obviously we have a much more interest also in ensuring that our needs are met at the Supreme Court and, of course, all the courts. But, you know, this is a country which is divided on almost every issue. And the role that the Chief Justice plays in this, let me call it drama, okay, ought to be checked, ought to be watched. And sometimes we say the road to hell is paved with good intentions. You must have the best of intentions, but the way you go about it may end up leaving a sour taste in the mouth of the public. Personally, I have not been too enthused with this whole debate and this whole discussion about the role in particular of the Chief Justice in recommending to the President on her own. Of course, she sits as the Chief Justice of this country, but that does not mean that she knows she knows the problems of the judiciary better than everybody. It cannot be. Yes.
And Sabia, let me clarify this. I mean, and he makes it a very important point, that intention may be good, but the procedure adopted, especially with 4 months on election, everything you do is seen within the political lens. You think the Chief Justice shot herself in the foot here, although she's actually pursuing a matter that you've come round to say, I support, but the procedure now poses a significant challenge, considering where we are as a country right now, and the suspicion and distrust that we have.
Well, personally, I would say that based on the advice we gave, even if they should be appointing judges today, what will be the point? Because courts are going on vacation come 31st July. August, September, they wouldn't work. October, November, December, that short period. So for me, whether we need more judges or not, I don't think this is the timing is the best.
So the timing is wrong to appoint
that is
5 more judges to the Supreme Court.
Because I don't think that, looking at the data that you gave, I don't think that between October and December, these 5 judges can clear those cases. That is why, you know, I made a point earlier that the Constitution only provides for a minimum. It is by convention that we've been operating with these numbers. So if we want to move away from that convention, we need to be very careful and do a broader consultation. That is why in our advice, we recommended Parliament should be involved, Council of State should be involved.
In doing what exactly?
In approving the numbers, whether we need to up it to from 15 to 20. Because we are aware of 15.
But Parliament is already involved. I mean, the Constitution says you are involved in approving the nomination.
No, what I meant is this. We've been working with a certain number, conventional number of 15. Now, her suggestion is that the conventional number of 15 should be moved to or increased to 20. And we are saying that, fair enough, because your data shows that there's a lot more work to be done. But we humbly we suggest that Parliament should be involved, Council of the State should be involved in deciding or discussing whether we should increase the conventional 15 to 20.
And also clarify something for me. Has the Judicial Council now shut down the 5 recommendations?
No, because...
Or is this still something that you're now actively considering?
No, because it's procedurally irregular. I don't think it even came up for discussion because at that meeting I was told, because of the way it had been done, maybe we'll have to go back to the drawing board.
So dead on arrival?
Oh yeah, we'll have to start all over.
Okay.
Because for the Judicial Council to consider such names, the bar will have to make a nomination. We've not done one. I am not sure Attorney General's office has also done some nominations.
Did the Chief Justice explain why she took that irregular procedure?
Well, I have no idea because I am not on the Judicial Council.
Okay. And on that same point then, what should happen now? Because the 5 names, by the way, and she's really put I'm taking your view on this as what the law says. She's really put the 5 nominees in a very precarious situation now, even when they are very qualified. And as we know, Sari Butcher, it's celebrated. I'm yet to talk to a lawyer who doesn't speak well of her and say even her nomination to the Supreme Court is well overdue. But what has happened now has put them, all 5 of them, in clear jeopardy, has it not? Even when you suggest their names now using the right procedure, you can imagine the hell this will cause because the names were put out there in a regular procedure at a time when there are a lot of political cases currently before the courts, and you have elections to prosecute on December 7th. What's your comment on that?
You know, if I were one of those judges, I would be very embarrassed. Embarrassed because these are people who are otherwise competent. And the question that everybody will be asking is, by what criteria did the Chief Justice come to that? Because with due respect, we're not suggesting that those 5 judges are the most competent. Or there are possibly others. But, you know, the procedure that we use is important to take away perceptions of favoritism, perceptions, all these negative perceptions. That's the way I put it. So my conclusion on this matter is that the manner that the Chief Justice has gone about it, in my honest view, will certainly embarrass each one of those 5 judges because they are otherwise competent to go to the Supreme Court. But when you put out their names, and in the particular case that we find ourselves, where the bar itself, my PRO is here, was not consulted or engaged in the selection of the judges, we do respect. The Chief Justice works with them, but it's not her prerogative. It's not her, I don't want to use the word right, but it's not, she is not the only person who's got a say in this matter. And the lack of consultation in presenting 5 people out of this many judges, it raises the question, by what criteria do you choose them? It raises the question. And like I said, if we're one of those 5, you must be embarrassed by now.
Let's deal with the bigger
Evans,
issue. Yeah, please.
Looking at it objectively, I think it's no fault of the 5 judges that it happened this way. So for me, we should still look at whether they merit it, because procedurally, there might be something wrong. We are not talking about their competence, as the senior has just said. So it doesn't matter whether the process has started all over. I don't think that anybody should use it against them. I don't think so.
When indeed the right process is triggered.
Oh, yes.
And okay. And do you think that the Judicial Council, and you know this better than I do because you have the ears of the President of the Bar, is in a position at this moment to even want to recommend new judges to the Supreme Court?
No, that is why I said that for us...
Are they even considering it at all, if you take away what the Chief Justice has done?
No, we were expecting that having put in an opinion, at least we should have a response that, yes, we have received this. We're going by your suggestion or we are not going by it. Because to be honest with you, when the request came, nothing about timelines, about when the appointment should be made, was put across. Okay. We just made our points clear, but many of us, or personally, I'm of the view that we may have to do it, but it doesn't have to be immediate.
So let's have that conversation then. We've seen the analysis done by the Chief Justice. And Prince, I want to start with you on this. Is there a need for more judges? Is there a need to break the convention and put it at 20?
There is. There is overwhelming need. You know, what happens is that the way we run our court system, you know, the issue for me is not even the number 20 or even 25. The issue is how we manage our courts in such a way as to ensure that only certain types of cases can get to the Supreme Court. As it is now, it's an open for all thing. You can decide to file an incompetent brief, a brief that has every chance of dying, stillbirth, and still get it before a panel of judges.
And where's the cost time?
And where's the cost time? And it is done all the time. Sometimes you go to the court and you realize the judges are frustrated. And certain practices have developed. The court has developed certain practices just to take out certain, or to read out briefs, incompetent briefs. But what is happening is that it's the kind of court system that we have that permits that kind of culture. And as long as that culture is there, look at how the number is climbing. How does the court discharge? So for me, the discussion now is not about 15, about 20, or about 25. I believe, and I honestly do so, that as long as there's a need for more judges in the Supreme Court, and not only in the Supreme Court, all our courts at all levels, unless we do the kind of work that would define how cases must move from one jurisdiction to another, and so forth and so on, we may even go beyond these 20 that we are now quarreling about. So as we speak now, given the kind of caseload that the Supreme Court has got before them, if they are to move, and I'm telling you, they're really hardworking. That much I must say for the judges. They're really hardworking, but they require more of them, and more jurisdictions need to be created, and so forth and so on. So for me, and I say this, it's not about even the numbers. I mean, this business of a capital 15, a capital 20, a capital 10, what does it mean? Does it mean that you're going to stop people from going to the Supreme Court, or that you're going to push the judges to take on more case laws, or what does it mean? That kind of statement cannot be made without reference or without regard to a whole system, overhauling the system as to justify the numbers. So as far as I'm concerned, it's not about numbers now. It's about the need. And if you got 500...
So there's a need.
That is
because of the backlog we have.
That is so.
So how do you fix that problem of need?
Well, that backlog we have those administrators, those who do the administration of
the Chief Justice solution is increase the numbers so we
that
can
is
deal
so.
with the backlog.
And I agree with that.
So by here is to increase the numbers to 20.
I agree with that.
Okay. Now, but let's look at this, Xavier. I know your position, the bar's position is clear on the matter, that you agree that there's a need for more judges. But is that the only solution? Isn't the solution also in redefining what the Supreme Court's jurisdiction should be on issues, right? Because if you, for example, look at, I was reading at 459, and if you put it in the Constitution, and according to the argument that the AG and the Supreme Court, the Chief Justice put out, I was just counting the mandate under the Constitution. If you add to it's a law. Final appeals, original and exclusive jurisdiction, exercise of supervisory jurisdiction, exercise review jurisdiction, exercise original jurisdiction determining whether or not official documents. I mean, like, should the Supreme Court be doing that? Exercise original jurisdiction in presidential elections, of course, we understand that, sacred. Exercise original jurisdiction over claims of reparation for wrongly convicted persons, hear and determine petitions presented to the president for the grant of prerogative of mercy. All that. Shouldn't you rather be looking at amending the law, restrict, say, what the UK does, only appellate, or original jurisdiction solely? And then the focus, everybody else can take the rest. Wouldn't that be enough?
Evans,
so that you have to touch the number?
I think that may be a long-term solution, because if you look at the brief that the Chief Justice brought, it doesn't bother on constitutional amendment, even though the heading appeared so. So in our opinion that we did, we realized that she was talking about increasing the conventional number and not the minimum. Because once you are mentioning the minimum, it means that or you want to reduce jurisdiction, you must go and do constitutional amendments. We've done a review. Where is the report? Constitutional review. For how long? Professor Mills' time. Have you been able to implement that? We can't wait for that. That is why I believe that to solve this problem in the interim, maybe we'll have to do this. It may not be this year, but it may maybe have to be in the near future, so that we can take care of it, because constitutional amendment is a whole process. I overheard a former president saying that when if he said when, but I believe that maybe he wanted to say if he becomes president, he will make sure that the recommendations are implemented. But
so you said the constitutional amendment is long-term.
Of course.
So you have a short-term proposal as well?
Because the data we have seen is overwhelming. So what prevents us as a nation to say that for now, we want to move from the conventional 15 to conventional 20? Just that it may not have to be done this year. It may have to be done probably next 2 years. Because if we want to wait and do constitutional amendment, what happens to the workload? Because don't forget, many more people are becoming aware of their rights. So if you even go to the lower courts, many more people are filing cases. And now if people disagree with the ruling or decision of a court, they are moving up on appeal.
What about
the Supreme Court as the final appellate court? And you can't stop anybody until the person gets there. So population has increased. So we have to look at all that. Constitutional amendment, I'm for it, but can we do that now? Because we have a problem at hand. How do you find solution to it now?
Okay. I want to bring in Sami James-Phil, who just joined us. He's a lawyer, but also the National Communications Officer of the NDC. He was there when John Mahama made his point about how he plans to tackle this through constitutional review. Sami, thanks for joining us. We have with me here the spokesperson for the GBA. The GBA's position is very clear on the matter. They believe the procedure adopted by the CJ is irregular, but they are in support of increasing the numbers at the Supreme Court, but maybe not now. Tell me, on the first subject of the procedure, yes, last week your party addressed a news conference. The General Secretary was very clear on the subject and actually put out quite exclusive details about what happened at the Judicial Council. The GBA spokesperson has confirmed all that for us already. Where do you stand tonight on the back of the detailed document that we've now seen from the Jubilee House, altered by the Attorney General, which includes the position of the Chief Justice, detailing the reason why this is needed, with facts that suggest, for example, the things that struck me, is that in the year 2022, 2023, where you have the most backlog cases of 595, it's also the year you have the least number of judges. And she says that's why you need more judges. Does that convince you?
Well, first of all, let me commend your guests, who I think have already done justice to the issues. And I'm not going to belabor the point at all, because on the issues of procedure, they have succinctly explained why the approach adopted by the Chief Justice is totally irregular, and I will add unconstitutional, because there is a clear procedure laid out in the Constitution for the appointment of justices of the superior courts. That is what precedents since the inception of this Fourth Republican Constitution have used in the appointment of justices to the superior courts. No Chief Justice in the history of Ghana has done what Justice Gertrude Tokuno has done. So what she has done is totally wrong. It was totally uncalled for. It is unconstitutional, and I think she must eat humble pie, concede this fact, and make amends. But beyond the procedural flaws, for me, is the whole agenda and intention, behind the action of the Chief Justice. Because if the Chief Justice was just making a proposal or a request to the President to increase the number of justices of the Supreme Court so as to ensure the speedy determination of matters pending before the court, then the issue of procedural lapses or flaws could have sufficed. But here is a Chief Justice going beyond a request to the President for him to increase the number of justices of the Supreme Court, which in itself is wrong. But she actually goes beyond that to propose specific justices of her choosing that she thinks the President should appoint. That, for me, borders on intent. It borders on the agenda. It shows that this Chief Justice is just not interested in having more justices of the Supreme Court, but that she has her own preferred, friends, allies, or people in the judiciary that she thinks should be appointed to the Supreme Court. And that is problematic because that raises issues of conflict of interest. You understand? Because she is the chairperson of the Judicial Council, which is supposed to advise the President on nominations or the appointments the President makes under Article 1442. And here she is actually telling the President who and who to appoint on the basis of her own self-serving criteria. That should tell you clearly that the main motivation for the Chief Justice is not what we are being told. The main motivation of the Chief Justice is not to have more justices of the Supreme Court for the speedy determination of matters before the Supreme Court, but to have the preferences, the preferred choices of this Chief Justice appointed onto the Supreme Court. And that is why, for me, I think this is reason enough for this Chief Justice to resign.
But what is wrong with the Chief Justice having a preference? What is wrong? I mean, the procedural matter has been dealt with.
Wrong with that.
With the Chief Justice having a preference?
Because the law does not allow her to have a preference. The law does not allow her to have a say in who the President appoints. The law only allows her as a member of the Judicial Council to offer an advice. How can you be advising the President on appointments that you specifically recommended? How can you do that? You are supposed to advise the President on the appointments he makes. And you are the same person telling the President that appoint Mr. A, appoint Madam B because of A, B, C, D. What are you then doing? It means you are undermining the whole arrangement that the framers of the Constitution have provided for under Article 144, which is to ensure that the appointment of justices to the Supreme Court, number one, is collaborative, it is fair, right? It does not involve any conflict of interest, and that is why the framers of the Constitution say the President makes the appointment on the advice of the Judicial Council in consultation with the Council of State and with the approval of Parliament. Look at the way they framed it. Then you have the chairperson of the Judicial Council surreptitiously, offering not only advice or making a request to the President that, look, I need more justices at the Supreme Court. That would have been bad enough. But she goes beyond that to say appoint Mr. A, Mr. B, Mr. C. You see, Evans, I'm happy today that the PRO of the GBA has actually confirmed all the statements we put out at the press conference we held last week, addressed by our General Secretary. And I want to add, for you to appreciate, because it is settled that the procedure she adopted was totally irregular and unconstitutional. I'm not going into her motives, her intention, her conduct. And I'm saying that I say that this Chief Justice has an ulterior motive because she never disclosed to the Judicial Council. She never disclosed to the Judicial Council that she was the one who originated these appointments in the first place through her unsolicited request or advice to the President. If she meant well, if her intentions were good, she would have gone to the Judicial Council and told them that, look, here, I am having this problem at the Supreme Court. Even though I know that as a body, we have the right and the responsibility to advise the president upon making those appointments, I want you to know that I have already written to the president making this request. And so it is on the basis of my request that the president is making this. She would have disclosed that material information, but she kept it to herself.
I mean, you know this with certainty that when it came up at the Judicial Council, she didn't disclose.
The same way we told you that the GBA, very uncharacteristic of them, this time around decided to stand up for, what is fair, what is just, the law and all that, and actually opposed, resisted this attempt to appoint 5 new justices of the Supreme Court. When we said that, people called us names. They said we were lying. They said we were mongering rumors. We were speculating. Today, the PRO of the GDA has confirmed to you. I go and ask the Judicial Secretary whether the Chief Justice, as chairperson of the Judicial Council, has at any time disclosed to the Council that she was the one who offered an unsolicited, whether solicited or unsolicited, I can't even tell, but proffered an unconstitutional and irregular advice, recommendation or request, whatever you want to call it, to the president, on the basis of which these 5 new appointments were made. She kept it
then, because thankfully, Xavier, at that point there, did the Chief Justice disclose that at the last meeting when this came up, that she had already initiated a process and suggested names to the president?
Evans, I think I've told you already that I don't sit on a council.
Okay.
It is my president and my immediate past president who are our representatives. But after every meeting, they brief us on the proceedings there. But upon our opinion on the request, they didn't come back to tell us that about the development that had occurred after that, except to see these letters flying on social media.
Okay. So you can't say if at that meeting the Chief Justice actually disclosed that this is something I had done already, I had put in the names to the president.
I cannot say that, but it came up.
It came up.
Because it came up. My president confirmed to me it came up and it was
So I guess the question that Sami Jemfi is making is, how did it come up? Is it that somebody on the council brought it up because they got wind of it, or the Chief Justice herself volunteered that information?
I suspect she brought it up and she was advised it was irregular.
Okay. Sami? Sami Jemfi?
Yes, I'm all ears.
Yeah, so that I'm just trying to clarify from the spokesperson that indeed this is something that the entire council raised issues with, definitely the Bar Association, but whether or not she volunteered the information or not, he can't say at the moment because obviously he doesn't sit on the council.
That's fine. I'm telling you on authority. I've seen the letter written by the GBA to the president objecting to the appointments the president made. And I'm saying that if you look at their grounds for objecting to that, they didn't include the fact that the Chief Justice, the person who set the motion, is who posted. On grounds of, the fact that there is an established convention, and that changing that convention must come with the appropriate consultations. They made points about the need for constitutional reforms if the Chief Justice or the President were so minded. They raised the issue of timing, which for me is a very important matter, because what the Chief Justice and the President are seeking to do cannot cure the mischief they claim they want to cure, because, like he said, the course will be going on vacation on the 31st of this month, and will be coming back in October, and there is no way they can decide the backlog of cases the Chief Justice is talking about before the end of this year. So why don't you wait for a new government to do that? These are all valid, cogent, well-reasoned, issues or matters that the GDA and other members of the Judicial Council raised. But I am telling you that with regards to the unconstitutional and irregular request made by the Chief Justice to the President, she kept it as a secret because she herself knew that what she had done was wrong. And the fact that she actually went beyond requesting for more justices of the Superior Court and actually went into who and who should be appointed by the President means that this Chief Justice has a predetermined agenda of favoritism for people that say things he can work with on the Supreme Court.
And I've heard you say a short few moments back that she should resign because of this.
Oh, I am saying that this is a clear ground for resignation, or clear ground for her to be removed from office. And at the appropriate time, the right processes will be activated. Because the Constitution is clear. A Chief Justice has no business telling the President of the Republic who and who should be appointed. These justices of the Court of Appeal she was proposing to the President, we all know them. Their contributions to the development of the law, we all know their competencies. But like my senior Kwaku Prince said, they are not the only competent people on the Court of Appeal. They have seniors by far on the Court of Appeal. People who are equally competent, if not more competent. So on what basis would the Chief Justice say that, I don't want to mention the name of some justices, right? Because we know them.
Yeah, and Sammy, very quickly, just have.
Don't you see the problem that creates?
Yeah, I mean, I just have a couple of minutes to wrap up on this. But you made the point about at the appropriate time, the right process will be triggered. That is the ground for her resignation. When you say appropriate time, when are you referring to? Are you referring to when your government possibly wins elections, or you're referring to now?
We are referring to the time when we will have a president who believes in the Constitution and will work on such petitions. Currently, we have a president who chooses to act on petitions depending on the content of those petitions. So sometimes he chooses to forward petitions. At times, he decides not to. We will clearly not waste our time sending a petition to such a president.
So I hear you say
himself.
I hear you say more categorically.
An accomplice in this matter.
I hear you say
so
more.
When I tell you at the appropriate time, the right processes will be triggered. Those who understand what I mean by that.
I mean, more categorically, under a John Mahama administration, you will trigger the constitutional process to remove the Chief Justice.
At the appropriate time, the right processes will be triggered.
Sami Jeffrey, thank you very much. What do you make of that point that he makes there, that this is ground for her removal?
I dispute it. The Chief Justice is entitled. She's a citizen of this country. Of course, one can make the point that by reason of the fact that she's the Chief Justice, she may be restrained in her nominations or her preferences for one judge to the other. I wouldn't know what the exact criteria that she used to select these 5 judges. I have not, apart from what is circulating in the press search, I have not taken my particular time to read. I wouldn't know what justification she offered, like I'm saying, for these 5 judges. But she's a Ghanaian, and the fact that she's Chief Justice, of course, requires that she must be restrained. But, of course, in the matters of constitutionalism, restraint is not the only way of reacting to needs of the state. Okay. And if she went ahead and made suggestions or proposals for these particular judges, fair enough. When they become judges, they're judges on their own.
But that's not the question in context. They're saying that fundamentally, use the word irregular, but this is a constitutional breach.
Yes.
That is grounds for her removal.
I don't know what the constitutional breach he's talking about. In fact, in all these discussions that we're having, be careful and know that the president is not even bound by the decision of the Judicial Council. Yeah. The president is not bound by the decision of the Council of State.
And again, he's not bound by the recommendation of the Chief Justice, even if it was an irregular recommendation.
That is so.
Yes,
I disagree with Sami. This doesn't constitute a ground for a removal. There are clear grounds stated in the Constitution for removal of judges. And I think we are all assuming that the Chief Justice solely decided maybe she might have spoken to some of her colleagues.
But if that also,
because her office,
at the Judicial Council.
Because her office has the right to nominate, just as the Bar Association as well as the AG's office. So the only thing is that there may have been the nominees that they have, just that she didn't present them through the right channel. So let us not assume that she personally handpicked them.
Okay.
I think we have to be fair on that.
This is a debate that I promise you won't go away until the Constitution maybe is radically looked at or thrown at all of us through a referendum to try and look at it. Because I think ultimately you said it comes down to that. What do you do with the Constitution on this particular matter? Sealing or change the jurisdiction of the Supreme Court? Thank you, gentlemen, for your time. And thank you, Sami Jeffrey, to enjoy the rest of your evening.